This is Talking Law on Radio 97 with Despina Priala, and if you have a question about the law, Despina more than happy to take it on for you. Just send it in an email, and the best place to do that is go to the website, which is radio97.com.au. Right down the bottom there's a couple of links. You can send it either via Facebook or the email address. Either way will get to us, and Despina will be happy to answer that for you. Just go to radio97.com.au and find the links at the bottom of the page there.
And quite an interesting topic of discussion this morning with Despina. We're discussing deceased estates and I guess different aspects and laws that go with that. So this particular segment will focus on capital gain tax. So for people listening in that may have never heard of this type of tax, could you explain what exactly it is?
I will explain it very generally because obviously with any aspect of tax, I always say to my clients and to other people, always go talk to your accountant or tax advisor.
Yep.
Because we're not accountants or tax advisors. Yep. So we do understand generally certain taxes that apply to property transactions like capital gains tax, potentially land tax. Of course, stamp duty is a big one that we are primarily concerned with when it comes to property. But so I can just talk very generally, but other people out there listening will understand capital gains tax is a tax that can be applied to an investment property where you have bought it and then you've sold it for a gain. Does that make sense? Capital gain. And then there's a capital gains tax on that capital gain. Now, there's quite a few intricacies involved about the type of tax and the rate, I should say, and whether there's any deductions that apply, etc. So that's why you should always get advice from your accountant about whether that would apply if you're selling an investment property. And I'm talking about investment because if you own your residence, obviously you live in your residence, when you sell that, capital gains tax is always exempt from the sale of your own primary residence. So that's important to understand the difference. So then we talk about how does this all play out in deceased estates. So often, quite often in deceased estates, the deceased will own properties and properties are sold as part of the terms of the will, and then net sale proceeds are distributed to beneficiaries. So how does the capital gains tax aspect apply to the disposal, as we call it, or the sale of those properties? So that's what I'd like to talk about briefly today, and I'm sure that the listeners out there, if they've been involved in deceased estates before or maybe are an executor and they're administering deceased estates, this might have come up in the past, or they may be involved in it now. So when we talk about deceased estates, there's this rule that says that if the deceased was living in their home, it was their main residence at the time of death, then there's this 2-year rule, we call it a safe harbour 2-year period, where if that property is then sold, disposed of, right, after their death, within that 2 years, then capital gains does actually not apply. It's completely disregarded in that situation.
So you have 2 years and you're exempt of it completely.
Yes, so it has to be the deceased main residence, obviously at the time of their death. And then when it's disposed of within that 2 years, then there's actually no capital gain. So that would, capital gains tax, I should say. So that would make a big difference, because if there was capital gains tax to apply to the sale of a property in a deceased estate, that could make a huge difference to the beneficiary's ultimate inheritance or net sale proceeds.
And indeed, that would offer quite an incentive for things to get done as quickly as possible, certainly within that 2-year period.
Exactly. So then what happens when you have someone disputing the terms of the will? What happens when the administration of the estate is delayed? So what happens if you actually haven't disposed or sold the property within that 2 years from date of death? And this is what I wanted to raise today, because I've been involved in deceased estates where they have been unfortunately prolonged, whether you're the executor or a beneficiary or an applicant making a claim against an estate. Sometimes it is prolonged for more than 2 years for that very reason, or for other circumstances beyond the executor's control. For example, you can't find a beneficiary. So that's another good example where there are beneficiaries named in the will, but for whatever reason, you can't locate them, and it might take you 6 months or more to actually find them. So that would prolong the administration of the estate.
For sure. Even
Yeah.
the grieving process as well. People just getting over what's happening and maybe like, oh, I'll leave it for 6 months. Yeah,
That's
of course.
right.
2 years
That's
can
right.
go quick.
So in June 2019, the ATO, and this, of course, capital gains tax, like any tax, is a federal tax, but in June 2019, the ATO issued Practical Compliance Guideline 2019/5. So that actually then confirmed that this 2-year period is in place, but of course, it can be extended for a further 18 months where all of the following circumstances apply, and some of them I've already mentioned, but we'll go through it quickly. So there are extenuating circumstances outside the trustee or beneficiary's control that's taken time to address, to fix, okay? The main residence was listed for sale as soon as those extenuating circumstances were addressed, so there wasn't any dilly-dally and other delays. The sale of the residence settled within the 12 months of it being listed. There are other extenuating circumstances that are outside the trustee or beneficiary's control. And the trustee beneficiary only really requires a further 18 months to dispose of the main residence. So without getting, I suppose, too much more in detail, the rule is you've got this 2 years. You do have this automatic extension for another 18 months if you fall within these extenuating circumstances or the ones that I've just listed. And then what we have is, what if you don't fall within those extenuating circumstances? What happens then if you don't fall within strictly those ones I've just listed?
Yeah.
And then you've got another situation to deal with, and I've actually been involved in one of these. So you then actually have to apply to the ATO for a special extension period, and you have to explain the reasons for that. You know, if the will was challenged, what if there was a life interest? This is an interesting one. So someone's granted a life interest to reside in the home for, until their death. That could be a long time. And then only after that time the property's sold. So that's a common one that comes up. So obviously you wouldn't sell the property within the 2 years because someone's got a right to live in it.
Yep.
Until they pass away, whenever that
true.
is.
Yep.
And then you can sell it afterwards. So that's a really good example. Or maybe the estate's very complex to administer. So I just thought I'd mention that briefly. If you're in that situation, listeners out there, you should go get some tax advice if you're dealing with a deceased estate, and see whether you fall within these extenuating circumstances or whether you have to apply for a further extension.
And is there some sort of upper limit on the amount that the property would be worth before, in order to get these extensions?
No. This doesn't come down to the value of the property. But I will say that if you are exempt from the capital gains tax, as I said, if you dispose of it within the 2 years of the deceased's death, and either one of these things apply. So we said the property was the main residence of the deceased. We talked about that. That's very important. And it wasn't used to produce income, so not a rental property. But also a situation where if the deceased actually acquired the property before capital gains tax was introduced, which was September 1985. So, sometimes people have had a property for 40, 50 years.
Of course.
Yeah. So obviously that you'd get an automatic exemption too because it was bought prior to capital gains tax coming in to play.
Very interesting stuff. Well, thank you so much again, Despina, for coming on the show, for talking law. And if anyone does want to get in touch with you directly, if they have a question about the law, where can they go?
Yeah, so they can phone the office 55 291 294, or they could email info@prialalegal.com.au. And they can also check out the segment on YouTube when I upload it this weekend.
Yeah, simply search Priala Legal, Priala. Thank you again, Despina and Wayne.
We'll see you next week.
See you then.